Welcome to Rapid Fire Wednesday, Q&A for immigration professionals. This week, I am joined by our wonderful partner, Cliff Rosenthal, who's based in our Santa Monica office, and I'm Kimberley Best Robidoux, a partner in our San Diego office. So hello to everyone. For today's installment of Rapid Fire Wednesday, we want to cover name, image, or likeness. What does this mean for foreign student athletes? And so let's go over some basic background before we pepper our resident expert with some questions about this topic. So for many, many years, name, image, likeness is just referred to as NIL. And it refers to when athletes receive some type of payment or compensation for the use of their name, image, or likeness from their athletic capabilities, particularly when they're amazing athletes. So for professional athletes, this really isn't a problem. They have some kind of contract that specifies what they're going to receive with respect to compensation or benefits for the use of their name, image, or likeness. However, it's been a problem with students who are athletes because they cannot take payment for the use of their name, image, or likeness without losing their amateur status. That position was challenged a few years ago with NCAA versus Alston, and the Supreme Court issued a decision in June of 2021 that essentially says that student athletes can, in some form, benefit from the use of their name, image, or likeness. So, Cliff, can you talk to us a little bit about what are student athletes? What's the F1 status? What's so special about them?
Okay, so as you mentioned before, it all started with a Supreme Court case. And this wasn't an immigration case. This was a case based on what was going on in the world and kind of a monopoly base, whether the NCAA had a monopoly or not. But it definitely, as you mentioned, has some effect on students because international students, similar to international students that are not athletes, they can't just get a job somewhere and pay off their school. Same with international students that are athletes. Similarly, they have to have certain work authorizations or they risk violating their status. So we know definitely that, they can come as students. F1 visa is the student visa. And athletics has always been seen as non-employment, mainly as Kim mentioned. It was seen as amateur, and because it was amateur, it was never a problem. But now that there's a way that NIL can be used and benefit from and profited from, now becomes the major question. Is this employment or not? And employment usually requires a work visa or some sort of status that allows for work. And that is what the whole tumult is now, whether the Immigration Act, with the regulations, whether an international student who's an athlete can get payment for using the NIL.
Right. Thanks, Cliff. So we did a little bit of research, and I'm going to read these numbers because I don't have them memorized, unlike Cliff. But for the research, we found that international students make up 12.8% of Division I NCAA athletes. And then Division I men's basketball exceeds the collegiate average with 15% of athletes coming from outside of the United States. In addition, we found that more than 60% of tennis players at the collegiate level are foreign students. So foreign students are not a large portion of collegiate athletes, but they still make up a fairly decent number of collegiate athletes, right? It's a fair grouping of them. And so how does the Supreme Court decision that permits student athletes to receive compensation for the use of their name, image, or likeness treat foreign national students differently? Essentially, Cliff, can they be paid or compensated for NLI benefit?
So that is definitely the $1 million question. And it kind of looks, immigration has not yet pronounced on this. So because they have not pronounced on it, we don't have really clear guidance. So we kind of have to go look at the guidance that was established, the principles that have been established throughout the years as it relates to employment, with students on F1 visas and how that applies to athletes. So that's kind of the key. And I think there are really 2 points, or there are 2 components to this analysis. The first one is we have to look as whether this is considered employment to begin with. So essentially, if you have a student, a non-student athlete, he wants to sell his car, or she wants to have a stock portfolio or own a house and rent out that house. Those are all considered what we call passive income. Now, passive income is really not the same as it is in for tax purposes per se. Sometimes passive income has a lot of work to it. You have to do a lot of work, but the income is passive in some sort of sense. So, for instance, you take a lot of work to sell your house, but wouldn't be considered employment. So the first question is we have to look and see with the student athletes, is it employment or not? And very often that depends on the particular type of NIL contract. And there are various contracts. Some are very, very passive. Someone takes a picture of an athlete while they're playing a game, for instance, without their knowledge even. Now they want to sell that picture. With that would be the most extreme version of passive. But sometimes an athlete could be on a campaign for a particular employer or a particular company where they're getting paid for very active work. So we kind of have to look and see whether it's passive or not. And generally the law, when it comes to passive income for students, is very much in itself some sort of gray area without very clear principles in itself. So there's a certain case where you had an ice cream seller, a person who bought ice cream trucks and leased it out to people. That was considered active. In the case where there was someone who owned a hotel, it was considered passive. So the lines can be very blurred to whether it's active and passive. So the first thing would be to check whether this is active or passive. And then the second thing is, assuming it is active, we would have to look and see, does it fit into one of the general principles, one of the general categories of work authorization for students? So that's usually, your F1 comes with three basic ones. First one is the on-campus employment, which is up to 20 hours. So you're going to have to manage your hours. You have to make sure it's on campus. Is it considered on campus? Is it for a student need? I think you probably could argue that student sports is a need, but depend on the specific case. There's the regular OPT, the optional practical training, but usually the student is out of school for that period of time, usually, or the CPT when it becomes part of a program of study, depending what the athlete's studying. If they're studying something in sports, could that be? I mean, these are all very creative ways. And until immigration really, pines on it, I think you have to have really broad shoulders, not to be conservative, but, looking at the creative ways is something that, we would like to do.
As you mentioned, after several years or a few years now, we still don't have any specific guidance from the government, either from USCIS or from ICE, which a lot of times oversees the student classification. But, there's been a lot of silence. So it does leave you kind of moping around a little bit to figure out, okay, how can we approach this and be a little bit creative? There's some questions that have come up, such as, would it be permissible for a student to go have a photo shoot in Canada or somewhere outside the United States and get paid for that and still maintain their F1 status? What about that particular scenario?
Yep. So generally, U.S. immigration law is for the U.S. and it wouldn't cover services that were done abroad. So essentially, if the student athlete was campaigning or took pictures, photo shoots outside the United States, they could be paid in the United States for that, because they would be reimbursed or paid profiting from services that were done abroad, which would be permissible.
So is there, any other tricky issues that you've come across with name, image, or likeness for foreign student athletes that you'd like to share with us?
I mean, there are lots of tricky parts. It's been 2021 and immigration has said that they're looking at it and we haven't heard back. So we've had quite a few instances that have come up since 2021. We dealt with actually one of the top recruits, if not the top recruit for the NFL, a couple of years ago. And, he had his whole life before him to make massive contracts. So he decided to be, conservative and, only do things in the United States that were clearly permissible. The questions of campus, is it considered on campus, in terms of the F1 visa? So, obviously if they're training on campus and they're playing on campus, but would off-campus away games be considered campus? That's a question. I mean, I guess similar, if you're working for a company and they send you to do work at another, at another company, would that be analogous to that? So these are the kind of things that come up. Is it a student need, a student service? How do we deal with degrees, majors? Or do they match, what is it considered like an internship to match with a student's major and even if that student major? So there are a lot of issues that come up. As you mentioned, not too much out there. Immigration really has said that, they're looking at it and they've been looking at it since 2021. The Department of State, when it comes to visas, have said that, they're not really looking at this at all. So there's probably no enforcement of this at the moment. But, it's a really real issue with little guidance. So we kind of we kind of stuck with some gray areas and some creative solutions.
Right. So it sounds like for each case, for each student, for each employer with whom you might be working, it's going to look at what exactly is happening with their name, image, or likeness, right? What is the activity? Where is it going to be? What is their specific status? Are they still in school? What is their degree field? So it sounds like there's a lot of complexity and a lot of strategizing that goes into this so that the person can be lawfully in the United States and then not have issues either changing status in the future or coming into the United States following travel abroad. Is that what I'm gathering from everything that you've been explaining to us?
Yep, I think that's a fair analysis. Lots of things to look at. Each case is certainly different. Lots of factors, what you're doing, where you're doing, how you're doing it, looking at the specific contracts. One of the interesting things that has come up, I saw one state held that, student athletes can be unionized, which implies employment. So I'm not sure where that's going to go. It's one state and, hasn't gone anywhere in terms of immigration, but lots of cutting edge, issues on the horizon. And these are interesting issues.
It sounds like a fun area of practice, Cliff. I wish I did a little more of it, but I'm glad that you're on our team to help us out with this when those questions come up.
Yep. Thank you for having me.
So that is the name, image, or likeness for international student athletes in a nutshell. Thank you, Cliff, for joining us on Rapid Fire Wednesday. We really value your expertise and the conversation. I'll be joined next week with Miki Matrician for our weekly Rapid Fire Wednesday. If you don't already, please follow us on our LinkedIn as well as our individual LinkedIn for Cliff, Miki, and me. And we look forward to seeing you again. Thanks again, Cliff. Really appreciate it.
Thanks, everybody.